Hi, welcome back to the NearSight and FarSight podcast, brought to you by the investment professionals at InSight. My name is Kevin Taylor. This is the second in a four-part series where we discuss the power and the nuance of having a good, properly managed trust as part of your full insightful plan. Hopefully, you've looked at the first part of the series where we discussed the basics, and now we want to talk a little bit more about the nuance of probate and some of the protections that are afforded to investors and planners who have used a trust as part of their planning process. We've brought in Clinton Carlisle, attorney at Schaefer Thomas Mays. Clinton, tell us a little bit about yourself.
So my name is Clinton Carlisle. I am an attorney in Broomfield, Colorado. I've been practicing here for a number of years with the firm of Schaefer Thomas Mays. We are a small firm, 6 attorneys, that practices almost exclusively estate planning, which is wills and trusts, and administration after death. So we write the wills and the trusts, we help you create and fund them, and then we can help your beneficiaries administer them at death. Not all law firms do both sides. It's really helpful to have one that does, so they know exactly how this is going to be read, how it's going to be administered, how things are going to really work. I am a Texas native. I moved here for college, and now I live in Erie with my wife and 9-month-old son.
Hey, Clinton, I appreciate the information previously, but one of the things that keeps coming up for our clients is why should they be thinking about probate? Is it expensive? Is it timely? Is it different in a per state basis? And does having a trust or a will help me avoid going to probate?
Yeah, so that's a good question. So probate does vary significantly between the states. So Colorado, if you're a resident of Colorado, wherever you die and are a resident of is the state where your main probate would be if one is needed. And so Colorado is very expeditious when it comes to probate and court proceedings with that. So what I mean by expeditious is no one usually goes into court. It is informal, and that the judge does not oversee anything that's going on unless you ask for him to. The court does not require you to make reports to them. They just appoint the executor or personal representative to handle things and collect assets on behalf of the estate and the court. And then when everything's done, you tell the court, okay, we've collected all the assets, we distributed them according to the will, we're all done, and the court closes the file. It is usually pretty simple in Colorado. That's an informal proceeding, but the cost of a probate, there are some court fees, and an attorney is usually required because there are quite a bit of things you wouldn't think about, like the requirement to file notice to creditors in a newspaper. They're a little antiquated, but just are requirements of the probate code. And so the fees on a probate usually will be at least a few $1,000s. Now that's paid from the estate of the deceased person, but it's still money that can be avoided by proper planning if that's a goal. Probate does get more expensive if you have property in multiple states because you have to open a probate proceeding in each of those states. So that's something a trust would help with.
How does, for so many of our clients, and definitely one of the things that we make sure is in order as part of the insightful planning process is that they've got beneficiaries declared. How does all of that work? I mean, if a lot of them will say, I already got beneficiaries on that. But if I have a trust and beneficiaries and then there's probate questions, what's the order of operations for somebody going through that process?
Yeah, so at death, we have several different ways of passing property to folks. So at the very top of everything is joint ownership on bank accounts or houses or anything like that. If it is what's called joint tenancy, which a lot of joint ownership is, that automatically passes to the surviving owner. It ignores everything else. It ignores your will, it ignores your trust, it just goes to the surviving owner. So that's definitely one thing to keep in mind if you put one of your children on your bank accounts, that's going to them at death. A next step is beneficiary designations. So on your retirement account, on your brokerage accounts, you have or should have a beneficiary named. That will go right to that person. That also ignores what we write in the will or anything else. If neither of those apply to the asset, then we look at your will. and your will say where it goes. And if we get down to this step, this is where we have probate. So the alternative to a will was a trust, and if we had titled the asset into the trust at death, that saves us from having to look at the will, because now the owner is the trust. The trust says where things go.
Let's say this happens for one of our clients. A lot of our clients will open up a new account and add a beneficiary and list one of their kids, and then they forget the other kid's social security number, and they just list one of the children. And let's say something happens to that client. Does a trust supersede a beneficiary, or does having the beneficiary on the account just supersede the trust in that situation?
No, it doesn't. So having a trust in itself is not going to do very much. So you would need to update the beneficiary to name the trust if you want the trust terms to apply. If someone just names one child, then that account might just go to that one child. There are things in the law that kind of assume what your intent is. Say, for instance, if you have a spouse on a brokerage account as the beneficiary and you get a divorce, the law assumes you wanted to remove them as beneficiary. So certain things do happen automatically, but you need to look at these just to be sure and update beneficiaries every so often, especially when you're creating a trust or a will, because just having a lawyer draft these documents and not finishing the plan by updating beneficiaries, you've just wasted money on a document that's not going to be used.
Is it helpful for our clients to retitle an entire asset into the name of the trust, or maybe just do it as the beneficiary? Is there a difference?
There's a slight difference. So let's take a brokerage account, for example. Attorneys will tell you different things. Some of the older attorneys will tell you, let's retitle that brokerage account into the trust. And that's an okay way to go. That does mean that you and your spouse will be named as trustees on the account. You can still access it, but it's in the name of the trust, and it will pass according to the trust terms of death. The alternative to that is to leave it exactly the way it's titled now, but name the trust as beneficiary at death. It's very similar in the end result, that the trust says where it goes at death. The difference being that during life, your name is still on the account, and you don't have to worry about doing things as trustee and all that mess. Whereas at death, we save a slight step by having it already titled in the trust versus beneficiary, where we have to file a death certificate and move it into the trust at death. But that's not really a big issue in most cases. So they both have the same result. It just depends on whether you want to deal with having the slight hassle of having your name converted to the trust name on the account.
So many clients use trusts as a protection from lawsuits and creditors. What does that look like, and what does the trust provide them, specific in Colorado as well as maybe more broadly?
Yeah, so in Colorado here, it depends a lot on the type of trust. So a revocable trust, the kind you're using for planning, offers no protection from creditors for you. That does not mean that you can't build in creditor protections for your beneficiaries for the inheritance using that trust. Once it gets down to them, it's an irrevocable trust, and irrevocable trusts can offer creditor protection. Now, there are some states that will allow you as a person to shelter your own money into a type of trust that will have creditor protection. We call this an asset protection trust. Colorado is not one of those states, but you can open a trust in, for instance, Wyoming, that would have creditor protection for you, and that would be an irrevocable trust. You would have to relinquish control of the assets and have a third party handle them, and a host of other expenses and administration. So a revocable trust is a really simple thing that you do for probate protection and planning at your death, but it does not offer creditor protection for you. An irrevocable trust is an option, but it's an expensive option and not usually done in most cases.
That's fantastic. Thank you very much. If somebody has heard something that they found very important, or they just want to ask you a question, what is the best way for them to reach out and to engage you, Clinton, to get more information?
Yeah, so if people want to contact me directly, like I said, my law firm name is Schaefer Thomas Mays, S is in Sam, T is in Tom, M is in Mary. You can find us at stmlawfirm.com. Phone number 303-469-7367. And my email is on the website. You can find me at ccarlisle, CCARLISLE, at stmlawfirm.com. Feel free to call anytime. Usually we will have a quick intro call with you just to talk about your situation, tell you what our process is like and what expected fees might be. And then we'd have you in the office to look over your existing plan, talk about what options you have for going forward, and design a plan just for you. So it's a long process that you would get to know me pretty well. It takes several weeks for us to know everything about you, talk to your advisors, and create your plan. I'd love to talk with you anytime. Feel free to give me a call. I think the number will be in the description below also.
Thank you very much, Clinton. It's been fantastic having you a part of this. This has been the second in a 4-part series where we've also discussed the basics of maintaining a trust, and we plan to move on to proper maintenance and some of the tax benefits that you can expect from having a good, properly maintained trust. This has been NearSight and FarSight, brought to you by the investment professionals at InSight.